If you ask someone, like almost anywhere in the world, to name a legal phrase, there's one that just pops up constantly, right?
Right, yeah. You have the right to remain silent. Everyone knows it.
Exactly. It's everywhere. Movies, TV. But it's also this incredibly serious foundational thing in law.
It really is a standard for procedural fairness, especially in common law countries.
But here's the thing, those words, that specific warning, it wasn't always a requirement. Not at all.
No, it definitely wasn't. It came out of a specific, quite dramatic legal battle. Some might even say accidental, in a way.
That's what we're diving into today, the story behind the right to remain silent, how this cornerstone of justice actually came to be. It's fascinating because it really boils down to one person, one mistaken procedure, and then this huge constitutional ruling.
And the source material we're drawing on for this is really excellent. It's an excerpt focused specifically on United States v. Miranda from 1966. This research is part of a larger series called Commonwealth Judicial Stories USA Cases. And our mission really is to trace that journey. How did this seemingly small police error in Phoenix back in '63.
It's a local thing.
Exactly, a local thing. How did that get escalated all the way up to the Supreme Court and end up completely redefining how confessions work, not just in the U.S., but, its influence spread globally?
It's not just dusty old history, is it? This impacts how things work now. Thousands of cases every year.
Every single day.
So the big question we're tackling is this. How did the case of one guy, Ernesto Miranda, 25 years old, a factory worker, not someone with, lots of resources.
Right.
How did his specific situation lead to a ruling that, even today, tries to balance the power of the police against, the basic dignity of anyone they arrest, all over the world?
It's a huge question. And to answer it, we absolutely have to start right where the mistake happened. Phoenix, 1963.
Okay, let's go there. All right, picture this. Phoenix, Arizona, it's 1963. This is ground zero for the whole story. A local crime happens, leads to an arrest. But it's the procedure, or lack thereof, in that police station that ends up having these massive global consequences.
And you have to think about the environment, right? An interrogation room back then.
Yeah.
It's designed to be isolating, sterile, closed off.
Exactly. And that very atmosphere is something the Supreme Court later zeroed in on. They called it inherently coercive.
Which brings us to the person at the center of it all, Ernesto Miranda.
Tell us about him. What do we know?
Well, the source is quite specific. He was 25 years old, worked in a factory. Importantly, he only had a 9th grade education.
Okay, so not deeply educated in legal matters.
Not at all. The records also mention a history of mental instability, though, crucially, he was found competent to stand trial later. But the point is, he wasn't legally sophisticated. He didn't have easy access to a lawyer.
He was vulnerable, basically?
That's the term the court would use. Vulnerable in the face of the state's power, especially in that interrogation setting. He was arrested for kidnapping and related charges.
So he's brought into the station. What happens next? This interaction with the police is critical.
It really is. The source highlights the timeline. After being detained, Miranda was subjected to 2 solid hours of police interrogation.
2 hours? That's not just a quick chat.
No, definitely not.
Yeah.
This was focused, targeted questioning inside the police station, away from anyone he knew.
And you can imagine the pressure building over 2 hours. Isolated, probably scared.
Absolutely. It's designed to wear you down mentally. You're cut off. No family, no friends, and back then, crucially, usually no lawyer popping in during the questioning itself.
Right. That's a key difference from maybe how we picture it now because of this very case.
Precisely. This environmental pressure, this inherent coercion of the situation, is exactly what the Supreme Court majority later found so problematic for Fifth Amendment rights.
Okay, so after these 2 hours, what happens? This is where the mistake occurs.
This is the pivotal moment. After 2 hours, Ernesto Miranda signs a written confession. There's a statement typed up saying he did it, and he puts his signature on it.
Seems straightforward enough for the police at the time, I guess.
From their perspective, probably. But here's the fatal flaw, the critical omission, as the source calls it. The single failure that eventually unraveled the whole conviction.
What did they miss?
Before they got that signature, before he confessed, the officers completely failed to inform him of 2 absolutely essential rights.
Okay, what were they?
First, the big one, his right to remain silent. The core Fifth Amendment protection against self-incrimination. They didn't tell him he didn't have to talk.
Wow. Okay. And the second?
Equally crucial, the right to have a lawyer present. Not just eventually, but right there during the interrogation.
They just didn't mention either of those things.
Nope. They proceeded with the questioning, got the confession, and that signed document became the absolute cornerstone of the prosecution's case against him at his trial. He was convicted based largely on it.
And that failure, that lack of information, that specific procedural gap, that's what launched this whole thing up the legal ladder.
That was the hook. Because the argument became, how could his confession be truly voluntary if he didn't even know he had the option not to speak or to ask for a lawyer? He wasn't making an informed choice.
He couldn't waive rights he didn't know he possessed.
Exactly. And that's the fundamental question the Supreme Court eventually had to wrestle with. What good is a constitutional right on paper if the person who needs it most, someone in police custody, under intense pressure, doesn't even know it exists?
Or how to use it.
Or how to use it, precisely. The Miranda ruling essentially bridged that gap between a theoretical right and a practical, functional one that someone like Ernesto Miranda could actually rely on.
It was about making the rights real in that specific high-pressure situation.
That's it. The court basically said, we need to ensure these protections work in reality, not just in law books. And that single mistake in Phoenix gave them the perfect or perhaps imperfect vehicle to do it. So now we have to shift our focus. We're moving from that police station in Phoenix.
Yeah, from the local level.
All the way up to the marble halls of the U.S. Supreme Court. The fact this specific case, Miranda v. Arizona, even got there, tells you how significant that procedural error was seen to be, constitutionally speaking.
And this was decided in 1966. What was the climate like then?
Oh, it was a really intense period. This was the height of the Warren Court era. There was a huge ongoing debate across the country about police powers versus individual liberties. Miranda landed right in the middle of that firestorm.
Before Miranda, how did courts decide if a confession was okay to use? What was the rule they were replacing? Because there must have been some standard.
There was, but it was messy. That's a really important piece of context. Before Miranda, the standard was called the voluntariness test.
Voluntariness.
Sometimes called the totality of the circumstances test. Basically, after a confession was challenged, a judge had to look back at everything that happened.
Like what?
Well, the suspect's age, their intelligence, how long the interrogation lasted, the physical conditions, their mental state, all these factors. And then the judge had to decide after the fact if the confession seemed coerced or if it seemed genuinely voluntary.
That sounds really subjective. Like, how do you really know?
Exactly. That was the massive problem the Warren Court saw. It was incredibly subjective. It led to wildly inconsistent rulings. Different states had different results. Even different judges in the same state could disagree.
So police didn't really have clear guidelines.
Not really. No clear rule book for them, and no guaranteed minimum protection for suspects. The system was flawed because it was based on reviewing these vague factors after the potential coercion might have already happened. It wasn't preventing it.
So the court wanted something clearer, a definite line.
Precisely. They were looking for what lawyers call a bright line rule, a clear, simple, mandatory procedure that would just cut through all that ambiguity of the old voluntariness test.
Okay, so the Supreme Court takes this case, and the ruling they issue, the source calls it a constitutional milestone. This wasn't just telling Arizona, hey, fix this. This was bigger.
Oh, much bigger. This ruling effectively created a federal standard and imposed it on every single state and local police department across the entire country.
How could they do that?
Right.
Where does the federal court get the power to dictate procedure to, say, the Phoenix PD? What's the legal mechanism?
That takes us into a core concept, incorporation. It's about the 14th Amendment.
Okay, explain that.
Well, originally, the Bill of Rights, including the Fifth Amendment's right against self-incrimination, only applied to the federal government, not the states.
Right, I remember that from civics class, maybe.
But over time, through the Due Process Clause of the 14th Amendment, which says states can't deprive people of life, liberty, or property without due process, the Supreme Court gradually incorporated most of those Bill of Rights protections and made them apply to the states, too.
So the argument was not telling Miranda his Fifth Amendment rights during a state police interrogation violated his 14th Amendment right to due process.
Exactly. The 14th Amendment acted like a bridge, carrying that Fifth Amendment protection over to state actions.
Got it.
So Miranda made that guarantee against forced self-incrimination fully binding on state police during custodial interrogations. It forced Arizona and every other state to follow this new, strict federal rule. It was a huge assertion of federal judicial power over state criminal justice.
Let's talk about the legal reasoning inside the ruling. The court said the problem arises specifically during custodial interrogation. What exactly did they mean by that? Why is that specific phrase so important?
They were very careful with their words there. Custody doesn't just mean you're officially under arrest. It means your freedom of action has been significantly restricted in any way.
So if you feel like you can't just walk away?
You're probably in custody for Miranda purposes. Even if they haven't said you're under arrest and interrogation, that's not just direct questioning like, did you do it?
What else could it be?
It includes any words or actions by the police that they should know are reasonably likely to elicit an incriminating response from the suspect. Subtle tactics, psychological ploys, those count too.
Okay, so it's a broad definition. If you're stopped on the street for a general question, Miranda doesn't apply yet.
Generally, no. That's usually not considered custody.
But the moment they put you in the back of the car or take you into that closed room at the station and start asking pointed questions, then the Miranda requirements kick in.
That's the trigger. Both elements have to be there, custody and interrogation. And the court's reasoning was simple. In that combined situation, the environment is just too inherently coercive. The pressure is too high.
So the warning is needed to counteract that pressure.
Yes. They argued that without explicitly informing the person of their rights right then and there, any statement they make can't be considered truly voluntary. The warning is seen as the only practical way to kind of dispel that inherent compulsion.
Okay, so this leads us to the actual rule, the legal principle. Lawyers call it the ratio decidendi, right? What was the core holding?
The ratio is actually quite straightforward, but incredibly powerful. It holds that confessions obtained during custodial interrogation are inadmissible in court.
Meaning they can't be used as evidence.
Correct. They're inadmissible unless the prosecution can demonstrate that the accused was informed of their specific Fifth Amendment rights before the interrogation began, and that they voluntarily, knowingly, and intelligently waived those rights.
So reading the rights became a mandatory first step, a prerequisite.
A constitutional prerequisite, yes.
Okay.
A prophylactic rule designed to protect the underlying Fifth Amendment right.
Inadmissible. That one word. That's the hammer, isn't it? That means the confession the police worked 2 hours to get from Ernesto Miranda
Was thrown out, couldn't be used against him in his retry.
So the main piece of evidence was gone.
That's the immediate practical impact. The court basically said, telling suspects their rights isn't just good practice, it's constitutionally required if you want to use their statements later. If the police can't prove they gave the warning, and that the suspect understood and waived it, the confession is tainted.
And it gets excluded through the exclusionary rule.
Exactly. It's a mechanism to enforce the constitutional right by removing the incentive for police to violate it. It protects the integrity of the court process.
But rulings this big, this controversial, they're rarely unanimous, are they? I think Miranda was quite close.
It was very close. A 5-4 decision, and the dissent was absolutely furious.
Really? What was their main argument against it?
Justice Harlan wrote a particularly scathing dissent. He essentially accused the majority of judicial activism, of basically writing new legislation for police procedures instead of just interpreting the Constitution.
He thought they went too far.
Way too far. He argued they were ignoring decades of precedent, ignoring the actual text of the Fifth Amendment, which doesn't explicitly mention warnings. He felt the old voluntariness test, well, maybe not perfect, was constitutionally adequate.
And what was his biggest fear about the new rule?
His primary concern, and it was echoed by many in law enforcement and politics, was that this mandatory warning would cripple police investigations.
How so?
He worried that as soon as suspects heard they had the right to remain silent and get a lawyer, they'd just clam up. No one would confess anymore.
Making it much harder to solve crimes.
That was the fear, that convictions of guilty people would plummet. He saw it as sacrificing effective police work and maybe public safety for a procedural nicety that, in his view, the Constitution didn't strictly require.
So the dissent saw it as a major obstacle to finding the truth.
Very much so. This fear fueled a huge political backlash against the Warren Court and the Miranda decision itself for years afterward.
So the ruling wasn't just a dry legal adjustment. It was a major statement about the relationship between the state and the individual.
Absolutely. It prioritized procedural fairness and the protection of individual rights, even potentially at the cost of some convictions. It really cemented the Warren Court's image as protective of the accused, but it also drew intense criticism from those who felt it went too far in favor of criminals.
And that tension, that debate over Miranda, it didn't just end in 1966, did it?
Not at all. It continued for decades. Later courts, particularly the Rehnquist Court, tried to clarify and sometimes limit the scope of Miranda, creating exceptions and refining the definitions of custody and interrogation. but the core ruling itself has remained remarkably resilient.
Okay, so the ruling happens, and the most immediate visible consequence is the creation of the warning itself, the words every cop has to say.
That's right. It's the tangible output of that whole complex legal battle. It's the script, essentially.
Let's break down that script. What exactly did the court say police must tell suspects? There are 4 key parts, right?
4 parts, exactly. First, the most famous one. You have the right to remain silent. That directly operationalizes the Fifth Amendment privilege.
Okay, number 1.
Second, anything you say can and will be used against you in a court of law. That's the warning about the consequences. You need to know what you say isn't off the record.
Makes sense. What are the other 2? They sometimes get less attention.
But they're incredibly important, especially the 4th one. The 3rd point is the right to counsel. You have the right to an attorney, specifically the right to consult with one and have them present during the interrogation itself.
Okay, right to silence, consequences, right to a lawyer. And the 4th?
The 4th ensures the right to counsel isn't just for the wealthy. It's, if you cannot afford an attorney, one will be appointed for you prior to any questioning.
Ah, so it links to the right to appointed counsel, like in the Gideon case?
Precisely. Gideon v. Wainwright established the right to counsel for indigent defendants at trial, and Miranda extended a similar protection to the interrogation stage. It ensures the right is meaningful for everyone, regardless of their ability to pay.
It's really the clarity of those 4 points, isn't it? That simple, direct language. The source says the name Miranda itself quickly became a global shorthand for procedural justice.
That simplicity is key. It took a complex constitutional doctrine and distilled it into a clear, actionable procedure with universal phrasing. Even if people don't know the case name, they know the warning.
And it didn't just stick in the U.S.
No, its influence spreads significantly. While other countries have their own laws and histories, the UK has its cautions under PACE, Canada has charter rights and deepings. The core principle behind Miranda resonated internationally.
What principle is that exactly?
The fundamental idea that before the state subjects someone to custodial interrogation, that person must be clearly informed of their basic rights, particularly the right to silence and the right to legal advice. That concept became a benchmark, a kind of global expectation for fair procedure in democratic societies.
The source uses this term procedural justice. Let's unpack that a bit more. How does Miranda embody procedural justice?
Procedural justice is all about the fairness of the process itself, not just the outcome. Miranda is a prime example because it says, essentially, it doesn't matter if the suspect is actually guilty.
Right. Guilt or innocence isn't the point of the warning.
Exactly. The state still has to follow fair procedures to obtain evidence. By mandating the warning, the system ensures the process respects the individual's rights before trying to get incriminating statements. It makes the process transparent and emphasizes informed choice over ignorance or coercion.
So it's about legitimacy, making sure the conviction, if it comes, was obtained fairly.
That's a huge part of it. A confession obtained after a proper Miranda warning and waiver is seen as much more reliable and legitimate than one obtained without those safeguards. It bolsters public confidence in the justice system.
This leads perfectly into the final impact mentioned in the source, that the ruling explicitly balanced police power with human dignity. That sounds profound. How does reading a few sentences achieve such a balance?
Well, think about the power dynamic. The police have immense power in that situation. The power to detain, to question the authority of the state behind them. The suspect is isolated, often scared, and at a significant disadvantage.
Okay.
Miranda injects a counterweight. By forcing the police to pause and inform the suspect of their rights, it momentarily shifts the dynamic. It empowers the individual with knowledge.
Knowledge is power in this context.
Absolutely. The suspect now knows they have options. They can choose to speak, choose to remain silent, choose to wait for a lawyer. It requires a conscious, informed choice. This limits the state's ability to just steamroll the suspect or take advantage of their ignorance or fear.
So it respects their autonomy, their dignity as a person with rights, even though they're suspected of a crime.
That's the core idea. It ensures that even in the coercive atmosphere of custody, the individual's inherent dignity and constitutional rights are acknowledged and protected. The police can still investigate, but they have to do it within these constitutional boundaries.
And connecting this back to the source material's origin part of this Commonwealth Judicial Stories series, it highlights how this American case fits into a broader conversation, right?
Yes, absolutely. The source situates Miranda within this wider common law tradition, USA, UK, Canada, etc. All these systems grapple with the same fundamental problem. How do you get reliable confessions without resorting to unfair pressure or coercion?
They all face that challenge.
They do. And while the specific legal rules differ, like the judges' rules that exist in the UK or Canada's Charter of Rights and Freedoms, the Miranda decision offered a very clear, very influential model for addressing that core problem of custodial interrogation.
So its impact went beyond just U.S. law.
Its principles certainly did. It influenced legal thinking and sometimes reforms in many other common law countries. It became a major reference point in the global discussion about fair trial rights and police procedures. It showed one way to try and strike that balance.
Now, we mentioned earlier that the ruling wasn't the end of the story. Courts have spent decades interpreting Miranda. Has the core rule held up? Have there been significant changes or exceptions carved out?
The core requirement that the warning must be given before custodial interrogation, if the statement is to be used in the prosecution's main case, that has absolutely held up.
Okay, so the foundation is solid.
Very solid. The Supreme Court even reaffirmed this quite strongly in a case called Dickerson v. United States back in 2000. They basically said Miranda announced a constitutional rule that Congress couldn't just overturn with a regular statute.
So Congress couldn't pass a law saying ignore Miranda.
No, the court said Miranda has constitutional status. However, they have carved out some important exceptions over the years.
Like what?
Well, for example, a statement taken in violation of Miranda generally can't be used by the prosecution to prove guilt directly. But if the defendant takes the stand at trial and testifies differently, that unworn statement can sometimes be used to impeach their credibility to show they're lying.
Ah, okay. So it's not completely unusable in all circumstances.
Not completely. There's also a public safety exception. If there's an immediate threat, like asking where a hidden gun is, police might be able to ask necessary questions before giving the warnings.
That makes practical sense.
And courts continue to grapple with the edges exactly what counts as custody, what counts as interrogation, especially with new scenarios like questioning someone about terrorism or online interactions. So the core is strong, but the legal system is always refining how it applies in practice. Hashtag outro.
What a journey we've taken today. It really started with one man, Ernesto Miranda, in a Phoenix police station in 1963, signing a confession without being told his rights. And that single procedural mistake, it spiraled upwards and led to this fundamental mandatory change in policing.
A change that now protects rights, not just in the U.S., but has influenced standards across the globe. It's really quite remarkable.
The key takeaway, it seems, is really about the purpose behind those familiar words. It's not just a formality.
Not at all. The real power of Miranda is that it makes constitutional rights functional. It takes the Fifth Amendment protection against self-incrimination off the parchment and puts it into practice right at the critical moment.
When someone is most vulnerable.
Exactly. When they're alone, possibly scared, facing the power of the state in that interrogation room. The warning ensures their rights are real and known to them at that point. It forces the system to respect their autonomy, their human dignity.
So if we accept that procedural justice, this balance between state power and individual dignity, hinges on knowledge, hinges on being informed in that critical moment. That raises a really interesting, maybe even unsettling question for you, our listeners, to think about.
Yes, Miranda was designed for the specific pressures of that physical interrogation room. But think about how technology is changing evidence collection.
How so?
Well, consider pervasive surveillance cameras, facial recognition, governments accessing vast amounts of digital data, maybe even biometric information or predictive algorithms based on online behavior. Much of this evidence can be gathered without ever needing a traditional interrogation or a confession.
So the police might build a case without ever needing to trigger the Miranda warning.
Potentially, yes.
Yeah.
If they can get incriminating data through technology without putting someone in custody and directly questioning them in a way likely to elicit a response, does the protection of Miranda even apply? How does the balance between police power and human dignity shift when incriminating information can be harvested silently, digitally, without that face-to-face encounter?
Are our existing procedural safeguards designed for the world of 1966 enough for the technological realities of today and tomorrow?
That's the provocative thought. If the state can increasingly bypass the need for confessions altogether, do we need new kinds of warnings, new procedural shields, to ensure that core constitutional protection against state overreach keeps pace with technology? What does procedural justice look like in the age of big data and AI policing?
A huge question, and maybe, as you said, the subject of the next great judicial story.
Could be.
Well, that's definitely something to chew on. We need to acknowledge where the insights for today's deep dive came from. The research was drawn from the series Commonwealth Judicial Stories USA Cases.
That's right. It's part of a larger body of work looking at significant cases across common law jurisdictions.
And the author of this specific research, whose analysis really framed our discussion of this landmark case, is identified as Mr. Zahir Ahmad Mir. He's an author who writes on a range of topics, including law, Islam, Pakistan, artificial intelligence, and modern thought.
His work provided a great foundation for our conversation.
Absolutely. Well, thank you for diving deep with us into the story behind the right to remain silent.
Thank you.
We'll catch you on the next deep dive.